Hello friends, in the series on income tax cases, today we will discuss a very important case which has been decided by Honorable Bombay High Court through a writ petition. And the issue in the present case was that if the assessee files some condonation application before the Principal Commissioner of Income Tax to revise his return and his application is being rejected on the basis that the assessee is not able to prove the genuine hardship, which is the prime criteria of section 119 subsection 2 clause B. So in that case where the assessee has suffered more tax than what he was required to pay, so only this situation can be considered as genuine hardship. This issue has been taken up by the court in the case of K.S. Bilawala and others versus Principal Commissioner of Income Tax and others. This case is reported in 463 ITR at page number 766 and the date of the judgment is 16th January 2024. The present case relates to the assessment year 22-23. In the present case, the assessee has received compensation under Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Settlement Act 2013. The assessee included this compensation into his taxable income. After filing the return of income, the assessee was advised that this amount was not taxable. So the assessee wants to revise the return, but the time for filing the revised return has already expired. So the assessee filed a condonation application under section 119 subsection 2 clause B with the Principal Commissioner of Income Tax, which was rejected by the Principal Commissioner by a simple template that the assessee is not able to prove the genuine hardship in filing the revised return in time. So the assessee do not have any option to file other than filing the writ petition, because the rejection order under section 119 subsection 2 clause B is not an appealable order. And when the court heard the matter, the court was of the prima facie view that the condonation application should be considered liberally. The court said that when the condonation application is being filed, then there is no straitjacket formula to determine whether there is genuine hardship or not. The court said that whenever the question of considering the condonation application is there, the authority should bear in mind that that if the delay will be condoned, then the substantial justice can be done on merits. The court said that one of the important factor in determining the maintainability of the condonation application is that the no party should stand benefited by filing the return late or by delaying the matter for which the condonation application is being filed. The court said that refusing the condonation is like throwing the matter at the very threshold, and cause of justice will be defeated in those cases where the condonation application is being rejected without application of mind. The court said that in the present case, the tax has been paid by the assessee which was not due to the assessee, and the authority should have condoned the delay and considered the matter on merits. The court said that the payment of tax more than what is required is a genuine hardship, and in the present case, the authority should have condoned the delay and then should have decided whether compensation is taxable or not. Friends, this case is very important because in a number of cases, there is situation that when the assessee is filing the return, the assessee is not in a position to determine that whether some amount is taxable or not. And if he includes that amount into the taxable income and after that he comes to know that this amount is not taxable, then he should have the right to revise his return. So only because the time of revising the return has elapsed, because now even the time for revising the return is considerably reduced. So in those cases, the condonation should be allowed to the assessee where the legitimate refund is due to the assessee because of the mistake of the assessee. At the end of this video, once again I am repeating the name of the case. The name of the case is K.S. Bilawala and others versus Principal Commissioner of Income Tax and others, and this case is reported in 463 ITR at page number 766, and the date of the judgment is 16th January 2024. Thank you, friends.